Morning. Today is Monday, August the 21st. This is the regularly scheduled Tennessee Auctioneer Commission meeting. Notice of this meeting was posted on the board's website on May 17th of 2022. This is our regularly scheduled meeting, and we're starting right at 9 o'clock. I'm going to start by making sure that we've got members present here to continue with quorum. When I read your name, please go ahead and let me know that you are here. Mr. Ed Knight? Thank you. Mr. Jeff Morris?
Here.
Thank you. Mr. Larry Sims? Mr. Kimball Sterling?
I'm here.
Thank you. And Dwayne Rogers?
Present.
Thank you. We have quorum in order to proceed. Just to remind everyone on the call and participating in here, as well as our commission members, if there's any comment from the public, we will always take those. And I've got that as an item on our new business to make sure everyone has an opportunity to ask any questions they might have about the agenda as it's been presented. The first order of business I would like is to make sure everyone's had a chance to review the agenda that was emailed to our members. If you have any corrections that you've seen, please let me know. Otherwise, I would need a motion to accept the agenda from our prior meeting as it's been presented.
So moved.
We have a motion, and I apologize. This is to accept the agenda. We have a motion by Mr. Jeff Morris. Do we have a second?
Second.
Thank you. We have a second by Ed Knight. All those in favor, please say aye.
Aye.
Any opposed? Okay. That takes care of the agenda as we've presented it. The next item of business is the acceptance of the February meeting minutes. If there are any corrections, please let me know. And that is also on your iPads to review if you need to. Otherwise, we would need a motion to proceed with the minutes for the February meeting as they are presented.
I move we accept them.
Second.
Thank you. We have a motion by Mr. Kimball Sterling and a second by Jeff Morris. All those in favor, please say aye.
Aye.
Any opposed?
Aye.
Thank you. Hearing none. We will continue. Members, on your iPads and your information, the next section of our agenda is the educational review. I will give everyone a chance to look at those, and if you have any questions, feel free to share these with or ask either Bob or myself. The first item on your iPads is from the Tennessee Auctioneer Association. This request is for sponsorship. Based on Tennessee Code 62-19-116. This is the 2023 annual conference that they always have. The total presented is for $7,200. I'll let you review those documents. This conference will be at the Opryland Gaylord Hotel in Nashville on November 5th and 6th. That's the first item. If we can review it and then have a motion or any questions that you might have, and then we would proceed to the next one.
I might ask that Shane McCarroll, who's present in the audience, to come forward and just kind of give us a brief summary of what they're asking for.
Perfect. Shane, thank you so much. If you can make
Sure.
Thank you, sir.
Good morning. Thanks to the commission for even bringing this before for review. This is something that we've teamed up over the last couple of years. I think we've been extremely successful. The association obviously serves its members, but more importantly, we want to serve all the licensees within the state. So with the Tennessee Auctioneers Commission jumping in and helping us with some of this funding, we've really seen an uptick on attendance for the education outside of the association, which is important for the commission, I know. This year we've put forth a request for $7,200. We have moved venues, and I want to state that we're not at the big Opryland Gaylord, just for clarification. We're across the street. As it pertains to funding, we could never afford the big one across the street. But we had our biggest convention last year. As long as I've been around for the last 10 years, I think we had well over 200 people in the room. Significant attendance as it pertained to education. And this year we are bringing in 4 different speakers, 2 of which that we're requesting specific funding for, and 2 of which we have are actually bringing to the table that don't need any funding. So we'll start first with a couple folks that are going to be coming in that we're requesting funding. We're bringing in a young lady named Jean Roberts out of Ohio. Jean currently runs the marketing campaigns for 2 of the most successful and largest auction companies in the country, RES out of Ohio, as well as Massed Auctioneers. She runs a marketing campaign specifically for them. And she's going to do a deep dive, 2 hours specifically talking through just what it's like to market nowadays. That's significantly changed. I think all of us in the industry would agree that over the last couple of years, that has changed from just being into print advertising and now effectively communicating with your clients via communication. The other proposed education and speaker is a gentleman named Art Kelly. Art's in Murfreesboro, Tennessee. He's got a 2-hour course that he's going to teach us about the 7 spheres of a friend maker workshop. And essentially, what this is going to do is try to approach us as auction professionals to engage in our community, to ultimately be able to give back something other than just offer services. We want to offer services and help folks through some of their transitions in life, but more importantly, do so with a kind heart, do so with a servant heart, and give back as much, if not more, than we take from our communities. So that's kind of the approach there. The 2 other speakers that are important to note is that we do have Robert Stevens coming in. We're not asking for any funding for Mr. Stevens. Mr. Stevens has spoke in the past and is currently serving in Rutherford County as a legislature. He's got a BA in political science. Because he's currently serving, we're not going to be offering him any compensation. But he does have an interesting perspective as it pertains to the way that auction business is conducted and basically correlates with legislatures and ultimately some of the things that we run into. Also, coming in without requesting funding is the ATF. If you've ever dealt with them before, you know they don't like to be recorded, and more importantly, they can't be paid. But we are bringing them in for 2 hours because that's been significant requests from the members, and obviously, folks that sit on this board, we hear a lot of things as it pertains to firearms. It's a big part of our business. That kind of wraps it up. The speaker fees are broken down significantly into AV rental, the things that we have to do as we bring folks in as far as meeting rooms, a lot of the printing and postage. And I do want to annotate that we'll be making a special public records request for all licensees, and the open invitation will go out to all licensees, not only in the state of Tennessee, but specifically anyone who's licensed in Tennessee. So I appreciate the consideration, and obviously would like to answer any questions if you have any.
Thank you, Shane. I appreciate you taking the time out to brief us on that. I've been to those conventions, and they do a great job, and I think that y'all have stepped it up, and I think with our aid, it helps to make it even better. So that's I'm glad we can participate in that. Roxanne, I think we have enough money in our funds to cover this.
Yes, sir, and we've covered it in the past as well.
All right. Well, I make a motion that we approve this as written.
I second the motion.
Thank you. We have a motion to approve the presentation as it's been reviewed by our members, and as Shane has explained, the motion is offered by Jeff Morris and seconded by Mr. Kimball Sterling. All those in favor, please say aye.
Aye.
Any opposed? Thank you. Hearing none. Thank you so much for everything. Congratulations.
Thank you, guys.
Next on your iPads, and this starts on page 25. This is the Nashville Auction School. They've submitted continuing education course. This is a 3-hour course titled Mastering Auction Management, a deep dive into personal property auctions. I will turn it over. Mr. Morris, if you'd like to ask any questions or anything else. If not, give you a chance to review everything, and we would need a motion to approve this as presented.
Back up. We approved the funding. Did we approve their course, or do we need to approve their course?
It's what? The course is on 25. So yes, the funding and the courses then are presented separately.
This is for the TAA.
This one is yes.
Okay.
Correct.
Well, I'll make a motion we approve that course.
Thank you. We have a second? We have a second by Mr. Dwayne Rogers. All those in favor to approve the course presented that we will be covering, the commission will be covering, please say aye.
Aye.
Any opposed? Hearing none. Thank you.
And then next up would be the Nashville Auction School course.
Correct.
Okay. All right.
Yes. And I apologize. I threw you off. That's on me. Page 29 is the Nashville Auction course, and this is a 3-hour course titled Building a Successful Auction.
Gotcha.
Yes, and auction and facility strategies and consideration. Motion by Mr. Ed Knight. Do we have a second?
Second.
Second by Jeff Morris. All those in favor, please say aye.
Aye.
Any opposed? Thank you. That is the presentation for our educational review. For the next meeting, we'll probably have one as well. So I appreciate everybody reviewing that. Next on your iPads is thank you. What page is that one?
Got one, mastering auction management, and then there's another one. Right.
Thank you. And that is also for Nashville Auction School, correct? Okay. Do we have a motion for our second course for Nashville Auction School? F. Morris, do we have a second for that course?
Second.
Was that Mr. Knight? Yes, thank you. And a second by Ed Knight. All those in favor, please say aye. Any opposed? Hearing none. Thank you. Thank you, Bob, for catching that. I knew I was going through the review too fast. Okay. Now we are on the director's report, which is our financial update, and that is on page 45 of your updates. This is the first closing number for June, which is the end of our fiscal year. You have before you an additional 25,981 that was added to as a surplus to the surplus to the ongoing amount that we've got, leaving our year-to-date surplus at 519,992. The educational fund is roughly at 221,000. That's the fund that has to be in excess of 150,000 at all times. This doesn't really need a motion. It's informational. And we will have one or two separate amounts before we close the fiscal year. Any questions the members might have?
Looks like we stayed in the green, so that's good.
That is definitely good. And for the next meeting, we should have the closure of 2023. The next item that we have is our 2024 dates for our meetings. That is on page 46 of your iPads, and I believe this was emailed as well. I'll be happy to send this out to the board members. I would need a motion to approve these to add them to the website. They are in correlation to what we do now as far as that the Monday at 9 o'clock meetings. February 26th of 2024 would be our first, then May 20th, August 19th, and November 18th. Thank you. We have a motion by Dwayne Rogers to accept the dates as they've been presented. Do we have a second?
Second.
I second the dates.
Thank you. A second by Mr. Kimball Sterling. All those in favor say aye.
Aye.
Thank you. Any opposed? We will go ahead and add these dates to our meeting, to our website as well. Quick update for all of our members. We had the sunset hearing on July 19th for the program. As you know, that's a regular course of business. We go before the legislators to make sure that the program should still continue its process. We have some answers regarding financials and all kinds of things. The meeting went very well. Thank you, Mr. Rogers, for coming with us. That was very appreciated. I know it clashed with travel for you all. So, and the members were aware. Nothing major was asked, and we have been extended for 6 additional years.
All right.
Yes. So yes, I can hear Mr. Kimball. Thank you. So that was good. I really appreciate everything. I'm going to turn it over now to Anna Matlock and legal for the complaints. Our current complaint starts on page 47 for your review.
Actually, Kim's up first.
Good morning.
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 Hello. So first, I'd like to briefly introduce to you Miss Kim Cooper. She's going to be serving as our disciplinary counsel for the Auctioneer Commission. And so Kim has got some cases here for us. She's been with the department for how long, Kim?
10 years.
10 years. And before that, she worked as an ADA. So she's got some serious experience on her side. So that's great. We're so excited to have her with the commission. And so she's going to present the legal report. So everybody, please be very nice.
Now, Anna, you know we're always nice.
I know.
I appreciate it being called serious experience instead of just saying that I'm old. Thank you very much. Ms. Matlock, how is the legal report usually presented for the consideration of the commission?
It depends. So case by case, or
Yeah, case
as
by
a,
case.
as a summary.
Yeah, we're slow learners.
Okay, so let's give them a summary of the cases that are there.
Okay. The first case on the legal report you have in front of you is a complaint against a principal auctioneer. The complainant was alleging that the respondent was doing shill bidding and bidding items up at both the auction house that the respondent owns as well as one that they work at, and that the respondent was working with the ticket writer in order to do this. The respondent did respond and denied all of the allegations, and essentially said it was just some bad blood between the complainant and the respondent, and that there was no basis for the complaint, that it was a harassment type of situation, and unfortunately the respondent was able to provide at least one copy of a message that was sent from the complainant to the respondent that was certainly harassing in nature. All of that considered, along with lack of any corroboration on the complainant side, I didn't feel like there was enough to move forward, and so I recommended that we close.
It's hard to prove that.
Yes, sir.
Yeah, I move we agree with the cancel.
Second.
We'll go ahead then and take these on a case-by-case basis.
Yes.
For complaint number 1, we have Mr. Kimball motioning to accept legal counsel's recommendation, and a second by Jeff Morris. All in favor, please say aye.
Aye.
Thank you. We'll go ahead with number 2.
Thank you. The next case is a administratively open situation where a respondent did not have the required continuing education. They were issued a citation, ignored that, have ignored all other attempts to communicate with them regarding the deficit. And so I'm asking for a $200 now civil penalty. Hopefully that will get their attention.
Did they turn their CE in?
No.
Have not turned it in as yet.
Have you had any response whatsoever?
Says none.
Yeah.
No response. Make a motion, we approve the $200 civil penalty then.
I second the motion.
Thank you. On case number 2, we have a motion by Jeff Morris, a second by Kimball Sterling. All those in favor, please say aye. Thank you. Thank you. We'll proceed with number 3.
And this one I have asked for you all to discuss and let me know how you want me to proceed. So in this case, the complainant saw an advertisement for a specific breed of horse, and it was a specific age as well. Those two things were important together. They got to the auction. They did have an opportunity to inspect the horse prior to the auction. Seemed okay. They went ahead. They won the bid. They go to pay for the horse. They did pay for the horse, but there was an argument because when the medical documentation that the respondent had was provided to the complainant, it did not match the breed or the age that they were there specifically looking for. So an argument started. Of course, the complainant's version of how escalated it got and who escalated it, it was very different from the respondent's. The respondent said that they did not inspect the medical documentation before, but that any disagreement between the age, the breed, any of that issue is between the buyer and the seller of the horse, that they just act as an agent. The complainant again had a problem with that because there was a prior auction just 2 weeks before that with this same horse, same picture, And at that auction, the horse was advertised as a different age. And so they're alleging that the respondent knew that they didn't have the correct information and went ahead with it anyway. Things got heated. The police were called and they were escorted off the property. The complainant said they never argued or said they weren't going to pay for the horse. They just feel like there was some serious misrepresentations and fraud going on. Again, the respondent denied all of that and said that there was no intentional misrepresentation or fraud. They bought the horse they bid on, which everyone agrees on. Complicating matters is that when the complainant submitted their rebuttal, they pointed out that the advertising of this particular respondent is not compliant with your advertising rules. In the advertisements for the auctions that I myself viewed prior to doing the report, the advertising lists only the first names of two individuals. There's no indication of who the principal auctioneer is, or last names. And there's also no certification number or their license number. I'm sorry. It's just a phone number and a name. And then it says, Smith auction next week. So there may be multiple issues here. And so that's why I wanted to submit it for your discussion and consideration.
Excuse me. Did I understand you that the auctioneer, after further review, did confirm that that was incorrect information, but he's saying it wasn't his responsibility? That was strictly between the buyer and the seller. Did I understand that right, or did I?
Correct.
Okay.
I think we need to call Judge Judy.
Well, there's several things at work here. One is that there is a responsibility on the part of the auctioneer to know what you're selling. You can't say, "I didn't know." If you're selling automobiles, the age, the miles, and that sort of thing. If you're selling horses, you better have some documentation to back up. If you say the horse is 4 years old and it's actually 7 years old, there has to be some sort of documentation or pedigree for that horse that you're selling. So it is misrepresentation from my standpoint. I don't know to what extent that we can fine or even levy a fine based on a fraudulent statement by the auctioneer. You can't just sit up there and say, "Well, this is a horse." You better know a little bit about it. And as we all know, that people take this kind of stuff very seriously, and for an auctioneer to just get up there and I don't know. I think it's wrong on many different levels, quite honestly.
I think there is.
Thing's not working.
Is it not working? Can you hear me now? Is this thing on? Complainant inspected the horse prior to the auction. I think there's some responsibility on the complainant there too.
You can't tell the
Well, I
age of
know,
a horse
I
by
know.
looking at it. I mean,
You
that's
can look at his teeth, and
right.
looking at a horse, you can tell 5 to 10 year old if you're just a guesser, but you're not exact. But anyway, that's I understand the documentation. The advertising thing, some responsibility should fall on the auctioneer there. But as a board, where are we at on fraud? I mean, we can regulate what he didn't advertise properly. But as far as the fraud side of it, I mean, is that a civil thing? I don't know.
Were the buyers asking for their money back, or?
No, actually, they agreed that they had an opportunity to look at the horse before they bid on it, and so they took responsibility for that and said we never asked for our money back from the auctioneer. They did say that they asked for the information on the seller because they wanted to address the issue with the seller, since that's what the auctioneer was saying. That's between you and the seller, and they claim that the respondent never gave them the information, refused outright to give them the information on the seller.
What is our jurisdiction on this? What can we do? Could we say that they've got to give him his money back, or is it only a civil fine, or what?
It
What
would
are
be
our
a,
options?
it would be a civil penalty only. You can't. That would be a contractual issue between them that we don't have jurisdiction over.
What sort of relief is the complainant looking for by filing the complaint?
I don't want to sound trite when I say justice, but they want it to be known, and they want this person to be told you did wrong and you shouldn't conduct your business this way.
We can at least do that. Um, love to have some more information on this, as far as, you know, what did the documentation say, and
The documentation on the horse put it at least twice the age that was advertised. The DNA came back as a completely different. They actually sent it off for DNA testing to determine the breed. It came back as a completely different breed. One of the reasons that they were interested in this particular horse as advertised is because if it was I think it was 4 years old that was advertised, it had at least another 3 to 4 years of growth on it, and they were looking at, you know, the size potentially, and there were a lot of considerations that went in there, and that's why they were so disappointed and felt lied to when it turned out that this was not at all the horse that they thought they were buying.
Well, did they
That's a pretty
supply the
significant.
DNA test to you?
Could you repeat your question, please, Mr. Kimball, Mr. Shirley?
Yes. Did they supply the DNA test to you?
Yes, sir.
That's a pretty significant difference, in my opinion. It's not like it was an honest mistake or something that just was, you know, 6 months or 1 year. To be double the year and not even to be the breed of the horse, to me, that's pretty significant.
And your advertising rules do contain penalties for misrepresentation or fraud in the advertising. So you certainly do have jurisdiction here to levy a civil penalty against them for that.
I think in the
No,
very
no.
least, it is misrepresentation in the advertising. If you make a claim that a horse is X, you better have something to back it up.
And also, they didn't put their names or license number in the ad. Is that correct?
That's correct. Yes, sir.
That's two separate issues, and I think we ought to fine on both of them.
Yeah, I do too.
Whatever the maximum fine is, I move that we do that.
We have two separate violations here. Ms. Matlock, in consultation with Ms. Matlock, is suggesting $1,000. Would you like that to be the total civil penalty or on
Per.
each? Per? Okay. At the will of the commission?
That's my motion, just to be seconded.
I'll make that second.
Thank you. We have a motion by Jeff Morris for a civil penalty of $1,000 per violation. There are two violations, so the civil penalty on the order will be for $2,000. We have a second by Dwayne Rogers. All those in favor, please say aye.
Aye.
Any opposed? Hearing none, I believe number 3 is set. I will go ahead and turn it back over to you, Ms. Cooper, for number 4.
Thank you, ma'am.
Thank you.
Number 4 for today, we have a auction for 5 parcels of land. It was both an online and an in-person auction. There was an advertisement that said it would be an absolute auction. The complainant found out after the sale that the sale did not go forward, or the auction was not successful, I guess, and that the land was not actually sold, and said that they had monitored the bidding online, knew that bids had been made, knew that bids had, for the total bids for the 5 parcels together, had reached over $1 million, and felt that that was a violation of your advertising rules regarding the notice of an absolute auction. The respondent provided one of these most detailed responses I've come across, where they were able to, they first stated that there was one ad, the only ad that the complainant provided was the one that said absolute, that was an error. They provided the dates and times of I think it was 11 other ads that ran that did not say absolute auction. They placed the blame for the error on their graphic designer. They also pointed out that any announcements the day of the auction take precedence over anything that was advertised prior to that. That the complainant / bidder himself was provided the instructions and the directions prior to the auction that said what I just said, that the announcements take place, and that they announced repeatedly that it was not an absolute auction, and that the sellers of the property also provided a response stating that the complainant was a neighbor of theirs, knew in advance personally that it was not an absolute auction, and so that there was no basis for the complaint. After going through all the documentation that the respondent provided, I would have to agree with them that there was no basis for the complaint, and so I would ask for you to close it.
Close it.
Second.
We have a motion, I believe, by Mr. Morris and a second from, a
Or the
motion
other way
by,
around. Other way around.
thank you. A motion by Ed Knight and a second by Jeff Morris to accept legal counsel's recommendation. All those in favor, please say aye.
Aye.
Any opposed? Thank you. Hearing none, we're on number 5, which is our last complaint.
This is Ms. Mack.
I have a matter to be represented. So this matter was originally presented as an unlicensed matter. And the new information is that I attempted to contact the respondent to settle the matter, but I have been unsuccessful. However, based upon my research, their former website no longer exists, and the unlicensed auction house does not appear to be in operation. So therefore, I would recommend that this matter be closed and flagged. So if the respondent attempts to secure a licensure in the future, they would be required to address the consent order.
Move that we accept your recommendation to close.
Second.
Thank you. We have a motion by Jeff Morris and a second by Kimball Sterling. All those in favor, please say aye.
Aye.
Any opposed? Thank you. That concludes the legal report. I will leave it with Anna to proceed with any other items we have for legal.
Yes, and I just want to read these complaint numbers into the record really quick. The first one is 2023-003911. Number 2 is 2023-008051. Number 3 is 2023-012911. Number 4 is 2023-020351. Number 5 is 2021-076871. So I have a couple other legal matters to do. The first one is going to be a presentation. It's called the You Are My Sunshine presentation. So if you've been on this court for a second, it's about the Open Meetings and Open Records Act. And we're required to give this presentation once a year, but it's been a second since we've done it. Normally we have a PowerPoint presentation up, but we're unable to do it on the screen, so you're just going to have to listen carefully to me as I give the presentation to you. So if you have any questions while I go through the presentation, please let me know, and I will to stop me, raise your hand while I'm going through it. So just a general disclaimer that the information contained in the presentation is general guidance on the Open Meetings and Open Records Act, and it's not to be considered general legal advice. So if you have legal advice questions, please come to me, and do not take this as intentional specific advice for every specific issue. So we would need to look at the facts and circumstances of every specific thing. So that's just, the general terms and conditions, general disclaimer for the presentation. So what is included in the open records for a board or commission? So open records or state records includes documents, So papers, letters, maps, and books. Media, which would be photos, microfilms, sound recordings, electronic data, other materials. So anything as long as it's made or received pursuant to law or ordinance in connection with the transaction of an official business by any government entity. So the legal report today that we did, any complaints that come into the commission, is those are public records. The applications that we receive, basically most things are considered public records. The only things that are not considered public records would be devices or equipment where the records are displayed, such as your iPads. Those are not public records. The Public Meetings Act, there are different areas that I'm going to cover. First, we're going to talk about what the Public Meetings Act is, what is a meeting and what's not a meeting, what's recovered, what is required for a meeting, and what occurs if the board violates the Public Meetings Act. General definition for for a meeting. So the General Assembly declares it the formation of public policy and decisions is that public business shall not be conducted in secret. So the title of this presentation that you didn't see is "You Are My Sunshine, My Only Sunshine." So the thing is that all of our actions and tasks are supposed to be conducted in the sunshine, which means everything that we do is supposed to be open and public and transparent. This part is not to limit any of the rights and privileges contained in Article 1, Section 19 of the Constitution, which I know everyone has memorized by heart. The Public Records Act is remedial in nature, so that means it should be construed broadly to promote openness and accountability and to protect the public against closed door meetings at every stage of the government body's deliberation.
If I could ask anyone on the Teams meeting or all those participating to please mute yourselves. Thank you so much. Go ahead.
Thank you. Application. So all meetings of a government body are declared to be public meetings open to the public at all times, except as provided by the Constitution of Tennessee. So all of our meetings are open to the public at all times. And a governing body is the definition of that means that they're members that consist two or more members with the authority to make decisions or recommendations to public policy. So that applies to all of our boards and commissions here at the department. So you guys would be considered a governing body, which means that all of your meetings are supposed to be conducted in public. This includes all of our committee and subcommittee meetings where business is to be conducted, where quorum is required, and where you have to make a decision or to deliberate. So any meeting that we have has to be in public. So if we're not making any decisions, then that would be the only time where our meetings are not supposed to be included in public, except there's one exception, which I'll cover here in a second. Meetings do not include an on-site inspection of any program or project. Okay, so I'm going to go over what is considered not a meeting. So no chance meeting of informal assemblages can be used to decide or deliberate public business. And circumvention of the spirit and requirements of Public Meetings Act. That means a lot of fancy words. So that means that if, for example, if Commissioner Morris and Commissioner Knight were to just happen to meet each other in the street in a chance meeting, the two of you could not make a decision or decide and deliberate something that means anything of importance to this commission. It would have to be in the setting that was open to the public and noticed. Also, discussion should not constitute deliberation. So examining or consulting in order to form an opinion, weighing arguments for and against a proposed course of action. So you guys can share a meal together in public as long as business is not conducted. So, for example, one of my boards, they would every meeting they go to dinner together before the meeting. I don't love it. It's not my favorite thing in the world, but the thing is they're not supposed to discuss any board business. So that means that if you were to like run into each other, that doesn't mean you can't like make eye contact and you don't have to look at each other. You can talk as long as it's just not board business. Okay, other things that are not considered meetings: lunch breaks, restroom breaks, any smoke breaks, which I think is really funny, is included in here, adjournments between multi-day meetings, and then so these are all times whenever board business should not be discussed. So for example, if we were to have a 2-day meeting, like we have this meeting one day and then the next day we recess and have a formal hearing, during that time period when we're not meeting, we should not be having any board business discussions. If we take a break, we shouldn't be in the corner talking about, what we're going to do in the next time. Like, we know these things, but we have to go over them because you would be surprised the conversations that I overhear in corners. Anyway. The exceptions that we have, there's one exception to public meetings, and that's going to be called executive session. But regular and special meetings also count as public meetings. So a special meeting would be something considered like an emergency meeting, a meeting that we would call, like if there was, like we have 4 meetings a year, but if there was a time where we have to call a meeting with like 2 weeks notice or 1 week notice, that would still be something that we have to notice on the website. But the only exception would be executive session. This board knows about executive session, but I still have to go over it. So executive session occurs where one or more board members meet with their attorney, and that board is under threat of lawsuit or has been threatened with lawsuit, and the board members ask their attorney questions related to such a suit. So it's not a back and forth conversation in executive session. Executive session is more so the attorney briefing the board members of what's going on in litigation. And the only role during executive session that the board members can hold in that time is to ask the attorney questions. So we're not talking about anything except litigation in executive session. Another time where you might have executive session, maybe if there's something related to HR related issue, but those are the only types of issues in executive session. But it's not really a free-for-all conversation. It's the attorney facilitating the issue. Again, we're not deliberating any specific issues before any executive sessions. So, for example, the Attorney General issued an opinion stating that oral interviews conducted by the Civil Service Commission of the Maury County, persons applying for jobs within the Maury County Sheriff's Department, do come within the provisions of the Open Meetings Act. So if this board did have the power to hire someone such as the executive director, which one of my boards does have that power, that doing that type of act would have to occur on the record. It would not occur like behind closed doors. So if there are 2 of you in any circumstance, that's considered a meeting. Examples: if a member emails the chair and says, "Here's a news article," that's fine. I'd like to include something on the agenda. That's fine. What's not fine? Here's a news item about one of our licensees. We should consider revocation. That would be very bad. We don't want to do that. General types of information is fine, but we don't want to talk about the information about news articles because, as you know, information that's presented to you is presented anonymously because we want to preserve confidentiality and remove all instances where impropriety could be considered. If the commission member emails the commission's counsel and says, I have a question about the legal consequences about something the commission has done, that's fine. But I never want to receive an email saying I've taken action as a commissioner and now someone is upset. Because that someone that's upset is me. Okay. So we can't unilaterally make decisions outside of the commission decision. So we're making all of our decisions here. So if you have general questions, that's fine. You're welcome to send them to me. That's okay. If you have questions, of course, you can send them to Roxana. Remember, if you send them to Roxana, please copy me on those email communications too. You don't have to, but make sure that you do. Another example of, as we were talking about public records, if you remember, you get all of your meeting materials sent to you blind copied. Because if we were to send the meeting materials to you with all of you copied on it, it would be considered a meeting. And then that information would have to be noticed. But the materials that come out from the meeting are eventually considered a public record anyway and will be released to the public. If a member emails another commissioner, if you send an email or pick up the phone to call another commissioner, that's not considered a chance meeting. That is a deliberate action, and you should probably not do that. We're like, having dinner together is fine, but when we're talking to each other on phones or emails and things, that can get a little bit dicey, because that email is automatically going to be something that would be considered a public record if someone were to request it. If someone wanted to request your emails, that would be something that we have to do to request. If someone were to request your text messages, that would be something that we would have to disclose if it was related to board business. So I'm sorry, Auctioneer Commission group chat is something you should not really do, okay? Because it would be subject to public records disclosure. I don't know about your dreams, but I'm sorry to squash them today. But even if you don't discuss board business, it does give a strong appearance of impropriety, and for safety's sake and for my sanity, it ought to be avoided. So if one of more members cannot attend the meeting in person, then they may participate telephonically. And so if we were to do that, then the votes are supposed to be conducted via roll call. But that's so the public will be able to know how the commission voted on any of the votes. So here is information about electronic attendance as it applies to our commission. So if one or more members cannot attend a meeting in person, if those members cannot attend a meeting in person to make a quorum, then the meeting may proceed as normal with the other members participating by phone or electronic means of communication. So as we have Commissioner Sterling today appearing via Microsoft Teams or online, that is fine. But we physically, in order to have quorum, have to have 3 persons in this meeting space. We can't have 2 people here and 1 person on Teams to make quorum. A physical quorum and in-person quorum is required to make quorum for our meetings. So having a smaller board, that's a little bit more difficult since we only have 5 people, but we have to have a physical in-person quorum.
Can I ask a question there?
Yeah.
What, we can't do it digitally for what reason? I know it's sunshine. Everybody opens them. Why could we not do it like we did in COVID? I know it's.
So the reason that we did meetings during COVID electronically was because we were permitted to do so via executive order by the governor. And the reason we were unable to do so was because we physically could not meet. due to like health and safety concerns. But as you remember, as soon as that executive order lifted, we were all back in this room, and we had those pieces of like glass between us. You see the little divot things there too, and there have been, legislation that's been floated around to allow meetings to happen all electronically, and so you don't have to have physical in-person presence, but that has not passed, and the position of the department here is that we are to have a physical in-person quorum. And so the second that you know that you can't attend a meeting, it's very important to let Roxana know, especially knowing when that we have such a small board, because we don't want it to be like Sunday night, and most of you guys are already here, and we only have 2 people, and we're unable to meet. So, I mean, that's the reason that we could do it before. We're not under a state of emergency as we were back in the.
So that's a legislation issue that has to be taken up to be changed.
Okay. The application of the Public Meetings Act. So the public has the right to attend, observe, and make comment at your meetings. And public comment is to be permitted at each meeting and is limited to the items listed on the agenda. This is a new statutory change that came in July of this year. So previously it was that that the public was allowed to attend our meetings, but necessarily was not permitted, did not have the right to speak. But in our past, we had allowed individuals to sign in and be allowed to speak on the agenda. But now we're required to allow public comment at our meetings. And so that public comment does have constraints. The public comment is to be restrained to the items that are listed on the agenda of the commission meeting. So that is a new statutory change that came from the General Assembly in July. So you'll start seeing that. We'll see it in new business here, where we are allowing the public to comment at our meetings. Any questions about that? Okay. In order to have a public meeting, we're required to have adequate public notice, which means the contents of the notice must reasonably describe the purpose of the meeting, also must sufficiently in advance of the actual meeting, give the citizens the opportunity to become aware of the meeting and to attend. And the notice must be posted in the location where a member of the community should be aware of such notice. So these are the 3 prongs of adequate public notice. And in order to be posted, usual methods of posting would be the internet, a bill posting, or the newspaper. Our general practice is to post the public notice of the meetings online on our board's website and the department's website. The Attorney General has stated that notice online to meet adequate public notice requirements is contingent on facts and circumstances behind the posting, and whether the location would be one where members of the community could become aware of the notice. And so we post that online on the commission's website, on their public meeting information, and then the department has a calendar information, and that's posted there too as well. And the agenda is at latest always posted like a week before the meeting. So what is the penalty of violation of the Public Meetings Act? The penalty is nullity. So that means that if we were to violate the Public Meetings Act, anything that were to occur at that meeting would be null and void. So that means that we want to make sure that we are in compliance with the Public Meetings Act, so that the actions and things that we do are not for naught. So nullity is pretty strong consequence, but it is the consequence of violation of the Public Meetings Act. Any questions about Public Meetings Act? So it applies to you as an individual and person as on the boards and commission. The only exception to a public meeting, as we know, would be the executive session. If you remember, we have to give adequate notice, and anything where one or more, so 2 members, is considered a public meeting, and chance meetings are not considered meetings, but if a deliberate meeting of 2 individuals where business is discussed, that is not considered a chance meeting and would be considered a public meeting. So if you violate the law, any violative acts are void and costs of litigation may be assessed against the board. So we want to avoid that. The last thing I'm going to cover is NC Board of Dental Examiners versus the FTC. So you all have heard about this case at least once. If you've gone through board member orientation, which you have, but it's probably been a second for some of you. So the North Carolina Board of Dental Examiners, what happened was, this is a Supreme Court case that was issued in 2015. So they issued 47 cease and desist orders to non-dentists about teeth whitening. And in response, the FTC filed a complaint alleging that the board violated antitrust laws by ordering non-dentists to stop providing the whitening services. The board argued that they have state action immunity, but the FTC ultimately prevailed in that case. The United States Supreme Court rejected the board's defense because they stated the board did not receive active state supervision, and when it interpreted the act addressing teeth whitening, when it enforced the policy issuing the cease and desist letters. So state actors and agencies are not simply, by their character, sovereign actors for the purposes of state action immunity. Immunity for state agencies requires more than a mere facade of state involvement. So, to ensure the states accept political accountability for anti-competitive conduct, they permit and control. In response to North Carolina Dental, what was passed was TCA 4-4-1265 in 2021, which established supervising officials. So who's a supervising official? In this specific instance, it is the commissioner or chief executive officer of the administrative department, which the regulatory board operates, or the commissioner's office designee. In this particular instance, we have a policy director, an individual that listens to all of our meetings and is listening to all of our decisions to make sure that our decisions are not viewed as anti-competitive or in violation of NC Dental. And the policy director's role is to ensure that the actions of the regulatory boards that displace competition are consistent with the clearly articulated state policy. Also, what in action, other than rulemaking, the supervising official shall evaluate whether the action constitutes unreasonable restraint that requires further review. If an action is considered for further review, this is what was to happen. We would have to provide notice to the board within 10 business days that the action is to further review. Review the full evidentiary record regarding the action, and if necessary, supplement the evidentiary record or direct the regulatory board to supplement the evidentiary record. Conduct a review of the substance on the merit, and then in writing, either approve the action, remand the action, or veto the action. So in practice, if this were to happen, the policy director is always looking for anti-competitive actions. I'm always looking for anti-competitive actions. So if there's a conversation and we're going or heading towards an area that I think is a little gray, I'll try and redirect conversation. But if we were to have something that we thought was an issue, probably what would happen is we would consider calling something that we call an emergency meeting, and then we would rediscuss the matter and make an alternative decision at that point. And then at that point we're unable to do that, then the commissioner, as we stated before, has the ability to veto that action. So we have several safeguards set in place so we don't get to the level of the North Carolina board. That concludes the end of my presentation.
Well done, Anna. You
Thank
have
you.
got us fully up on the sunshine law
You're
and
welcome.
making sure we're not going to mess up.
Yes, generally. Just of course. Also, it had my email and phone number, but if you guys if you need that, we can talk after the meeting and I can give that to you. But after that, I generally wanted to give a couple of other additional updates related to things in the legal land. I know that everyone is generally interested to know what the state of being is related to the Macklemore case. So as of Friday, actually, we received an email from the Attorney General. So I'll give you a brief before we got that. So the Sixth Circuit originally vacated the decision of the district court and remanded it back to the district court. So vacated the previous decision that was made it and remanded it with instructions for dismissal. So the decision that originally that we had that was not in our favor was essentially thrown out, and it was given back to the court with decisions to dismiss the case. So that was what originally occurred. So that was good. Yay. Then the petitioners appealed. So they appealed to the Sixth Circuit. So the Sixth Circuit, like other circuits, sits in panels. And so they appealed for a full panel hearing, which is their option. And up until Friday, we didn't have a decision. Friday, the Sixth Circuit came back and denied their appeal for a rehearing. So at this point, the decision to remand and to vacate and remand stands. There is one other option, of course. They can petition for certiorari to the Supreme Court, always at that point, but that's where we are. But we got that notification on Friday afternoon
Right now, we're in the W column
at this moment.
until they make a decision about what they're going to do.
Yes, so that the last option would be in the federal lawsuit would be to petition the Supreme Court. And that would mean they were asked the Supreme Court to hear the case.
Tennessee Supreme Court
No,
or the U.S. Supreme Court?
The Supreme Court of the United States.
U.S. Supreme Court. Okay.
Yes.
That's big. That's a bold move.
Yes, but it is their right to do it. But at that point, so that's where we are with the Macklemore case at this point.
And the court would have to agree to hear the case.
Yes, the Supreme Court would have to grant the petition for certiorari.
All right, I think we got some momentum going here.
So that's where we are with the Macklemore case at this point. So any questions related to that? I don't have any other further information that's very new. We just got that Friday afternoon from the Attorney General's office, that information. So we don't have any further instructions related to that. Another update that I know that the commission probably wanted to know about was related to the we had talked about possible drafting an Attorney General's opinion related to the public automobile auction question. And so while I was drafting that opinion, I talked with one of my coworkers in the Attorney General's office, you know, just generally to get a feel for where he thought we might be with it. And, you know, I made my argument where I thought we would be, and I was like, why I thought this would be different. And my argument apparently wasn't that very much convincing to the Attorney General's office. And so, in consulting with him and in consulting with some of my supervisors and others, I think that if we want to get a resolution on this area, the cleanest way to do it would be through legislative means, is to just outright fix it. Because again, the Attorney General's opinion is an interpretation, and someone could interpret it differently. So, a legislative fix, I think, would be the best fix for this in this path. That was a proposal that we made this legislative session. We pitched our fix that we thought what it would be. Unfortunately, was not picked up from the department this time around, but it's not something that we're necessarily going to give up on doing. But that is just generally what I think would be the best way to do it instead of submitting a
Be much cleaner that way.
right. So there's less ambiguity. Any additional questions from me related to those topics? I know they are topics of great concern from everyone. Okay,
Appreciate the update. Thank you.
welcome.
You, Anna. Members, the last item that we have on is our new business. As I mentioned, as we started the meeting, we've actually always done this. If a member of the public, whether they're here or participating virtually, have any comments, we've always welcomed them. But this sets it specifically also on our agenda. So again, anyone that is either participating here in person or Dana handles the items through the remote meeting with Teams. Anyone that has comments regarding the agenda as it's been presented has this opportunity to present those comments. So I will pause in case anyone, either here or Dana, if you'll stop us, if you've got anybody with a raised hand through Teams, we'll make sure to not miss anything. And otherwise, the same with commission members. If you've got any other questions or comments, this would be our chance.
One thing I want to do, I want to give you a brief update on the conference and show that we, Ed and I went to in Oklahoma City. It was one of the more well-attended conference and shows we had in Oklahoma Tuesday through Friday in July. Like I said, it was well-attended. One of the things that came out, the National Auctioneers Association has changed their name to the National Auction Association because they felt like it was more inclusive because there's a lot of auction people that are not auctioneers. And so I didn't know if Tennessee wanted to follow suit and become the Tennessee Auction Association. So y'all might take that under consideration. But that was a big deal. And then the other big topic that was throughout the entire session was everything about AI. And so that's coming like a late freight. And so we got to be on top of that. We did have our NALOA meeting during the convention, and Steve was there. Different ones attended that, but that was well attended. Mike Brandley did our session, and we had good attention with the NALOA group, so it was good. But I appreciate the commission sending me and Ed, and we thank you for that, and we think Tennessee was well represented at the National Association.
Thank you, sir. That was wonderful. Really glad you could both go. I think that's very important to stay on top of that. Dana, do you have anyone that's with us through Teams that had any questions? Oh, I didn't get to see you. No, let me check.
No, there's nobody on Teams
All right.
that has any questions.
Perfect.
Thank
Thank you. Go right ahead.
All right. Good morning. I'm Addison Russell on behalf of the Tennessee Auctioneers Association, and thank you, Anna, for the update on the Macklemore case. Are we correct to assume that with the Sixth Circuit's ruling that now the 2019 Auction Modernization Act is in full effect and that the Commission will have regulation over online auctions and that operating an online auction will require a Tennessee auction license?
That is a great question. I, at this point, am still awaiting information to come back from the Sixth Circuit relating to the order to be issued down to the district court. So I think we're waiting on the order to come down from the district court to issue the information, but I can't give a firm answer to that, but I don't foresee a change. But I'm not authorized to give that answer at this time.
Who is authorized?
I'll have to get back to you on that. I can email you. I'll have to ask my supervisor.
Thank you, Anna, for that. So, if I'm hearing you correctly, right now we're in a holding pattern still.
Yes.
Okay.
One of the things that I did do prior to this meeting was to ask the Attorney General's office what guidance I could give this commission, because I knew that this topic would come up. What, if any, I could give related to the status of the lawsuit in the matter, and I briefed everyone with the information that I currently have at this. So I'm waiting on more information from our legal counsel so I can legally advise everyone else.
Hopefully by our next meeting, we'll have this sort of cleared up. We'll know kind of where we are.
Yes.
Okay. Thank you.
I'd love to be out of that lawsuit.
I mean, I would love that too. But I've given you all that I know at this time.
Anything else from our commission?
Good morning. Shane McCarroll on behalf of kind of a couple different entities. Nashville Auction School is where we'll start. Thanks, Anna, for the updates. Specifically, my questions will pertain to the public automobile auction and public automobile auctioneer. Clarification that, if I remember correctly, started in November. So the fall of last year, we've been seeking clarification of some sort. As an instructor and obviously owner, it's put Nashville Auction School and educators kind of across the country in a tough spot. We have no idea what to tell these folks. There's a significant amount of licensees throughout the state of Tennessee that make their living selling automobiles at public automobile auctions. In 2019, many of those individuals allowed their public automobile auctioneer license to lapse because the reform was going to allow the reform was going to allow the bid caller license to essentially allow those bid caller licensees to operate as a bid caller under the jurisdiction of a licensed public automobile auction owner. The individual that has the auction facility is required to have a motor vehicle dealer license. The individual is required to have a public automobile auction license. The individual is required to have a principal auctioneer's license. The individual is required to meet all the standards of the motor vehicle division, which includes proof of insurance, which includes a facility, which includes 100 other things, to include proof of finances. I don't have the actual statistic, but I can tell you that there are more than a dozen, probably less than 100 licensees or previous licensees that are out there still conducting business because there's no reason that we can see or that anyone else can see other than the statute and a little bit of misinterpretation that the public automobile auctioneer should be required to have a motor vehicle dealer license. There's nobody, to include the Department of Motor Vehicle, that would agree with what we are currently sitting on. Our current statute requires for a public automobile auctioneer, for him to go to work for a public automobile auction, to have a Department of Motor Vehicle dealer license. I can't imagine that anybody in this room, or really anybody that conducts auction business, would assume that that's what we intended in 2019. Because now what we're doing is essentially making that auctioneer have the same license that the gentleman or lady that's hiring him has. There's folks that have been waiting since November to move forward with businesses across the state. There's individuals in this state that have built facilities, that have paid millions of dollars to build facilities to have a public automobile auction, and they're just waiting since November. They're just in a holding pattern. I think negligent is a tough word, but I think we have failed these folks considerably to not have something to say to them. I don't know what the solution is, obviously. The people in this room are the ones that can figure out what we can do, but I just want it to be known that I don't know what to tell anybody other than go get your Department of Motor Vehicle dealer license. We can all go to public auto auctions every weekend and get those guys off the block and tell them to show you their license. Many of them don't have the endorsement if they allowed it to lapse, because now the licensure requires the proof of the Department of Motor Vehicle dealer license. But I want it to be known that if you have a current license, if you currently hold that license, when you renew it, it doesn't ask you to show proof of a Department of Motor Vehicle dealer license. So the people that had it previously and continue to renew, they don't have to show proof at renewal. So they're continuing to be able to conduct business and collect paychecks, while the new people coming into the business that would like to seek that endorsement, the system of licensure, and correctly should require them to show that proof. So we're in a tough situation. I know that it was no one's fault sitting before us, but I do think that we need some type of action to help those folks that are out there trying to make a living doing it. Thank you for your time.
What is the remedy for this? Do we know? Is there a remedy for it?
If my understanding, based on listening to what that is, the intention was to never have a motor vehicle dealer license.
I think we're confusing a couple of things here. It was the intent of the task force that a bid caller could call bids for a principal auctioneer that had the facility.
Right.
Now they're saying that's not enough. And I don't know how that got mixed up in the law, because that was not the intent when we redid the law. In other words, the principal auctioneer was supposed to be enough, and the bid caller could be hired to work for that principal auctioneer. And Shane's telling us that that's not true. Correct, Shane?
Well, and maybe it seeks a little bit more clarification, but Mr. Hunter and I, or Bob, as he's told me to call him, not Mr. Hunter, the individual that owns the auction itself, we've always wanted that individual and is required legally through the Department of Motor Vehicle, because he's transferring titles.
Right.
That individual is mandated to have a license. We've always known that. It's the auctioneer himself. If he's a principal auctioneer or at least a bid caller licensee, he should be able to go to work for that public automobile auction and call bids. He's
Right.
not transacting. He doesn't have an escrow account. If he's a bid caller from a reciprocal state, he doesn't have a license anyway. He's not signing titles. He's not conducting business other than as an agent for that buyer and seller that day. The new licensees that are trying to get that endorsement are being told that they have to show proof of a motor vehicle dealer license. Where that started or
I-
how that started, I don't know.
I don't know where that came from.
So the statute as it's written, the public automobile auction cannot be owned.
What now? Say that. Can you say that again?
I said as it's written right now, the public automobile auction cannot be owned.
You mean cannot be owned?
No one owns a public automobile auction in our statutory scheme. Like, listen to that's why I'm saying that if we were to have an interpretation from the Attorney General, the way that the definition is written is auction means a sales transaction conducted by an oral, written, or electronic exchange between an auctioneer and members of an audience consisting of a series public automobile auction. Sorry. This is a public automobile auction. The definition means offering motor vehicles for sale to the highest bidder, where buyers are members of the public by a motor vehicle dealer licensed to sell used motor vehicles and licensed as a public automobile auction by the commission. However, no public automobile auction may otherwise limit the auctioning of used motor vehicles exclusively to licensed motor vehicle dealers or their duly authorized agents.
Well, if I want to sell my car, and I want to hire Shane to sell my car as an auctioneer, I have a legal contract that gives him the right to sell that. And if he hires Bill as an auctioneer to transact that business, why would Bill have to have a license if Shane has the contract and his license as an automobile dealer?
Like, that's just how it's written here. Like,
that was never the intent.
I understand how it, like, we're back in the same conversation as it was before, but I'm telling you how it's written. Like, public automobile auction means offering motor
I
vehicles
understand all
for
that,
sale,
but
right? And so that's not like a noun. So
how do we amend or change it? Because this is like an undue burden for an auctioneer.
right, you would have to change the definition of public automobile auction.
I disagree with what you're saying, Anna. The definition of an auction has got nothing to do with who has the right to do it. If I hire somebody to do exactly that, because the act of it is that.
Right, I understand that you disagree with what I'm saying, but I'm telling you what I'm saying is what the AG's office has said and what I have argued to them. Like, if you want me to go ahead and submit this and have it in writing for them to say again what it already says, I can do that. But they're telling me they're not going to change their opinion.
Well, how do we amend the law to accomplish what we need to accomplish then?
You have to literally change the law.
This is ridiculous.
How do you do that? You had mentioned earlier that if we're going to address this, we've got to address it through litigation. So we're asking
Not through litigation. You have to change
legislation.
It by
I apologize,
legislation.
misspoke there. So how would you suggest we move forward to get it done? Because we don't know the procedures and the steps. You do.
Right, I understand. We tried to do it on our own. It was not picked up by the department. So if it would have to come through another party elsewhere. So, I mean, I understand that people are frustrated, and they may be very frustrated with the decision that was made by other individuals. But when I spoke to the individual that writes the opinion that
Okay. All right. So here's what we need to do then.
Just let me know if you want me to write, like, if I write this opinion and get the request from the opinion and it comes down and it says the same thing that it says again, it's binding.
But we're just in a circle here. I don't want to do that.
I know, but I'm addressing a previous comment
I
that we
appreciate
had
it.
before.
Is there a way that you could help us write what we need to get brought before the legislation, and then we can get the TAA and other auctioneers behind us to get their legislators, or the state representative, the state senator, to introduce a bill to get that done?
Sure, I've already drafted something from before what I tried to get proposed this time.
Okay. So if we could get that out to the members of the TAA and let's get on a campaign and get us a legislator or two or three or whatever to introduce the bill and get it changed. I mean, that's the only way I know that we can get this done. Since we can't do it internally, we have to do it from the legislative side. Agree with that?
Yes, sir.
So if you would help us
Right.
write that,
I can.
we just need something that we can tangibly say, look, this is what we need to get this done.
Right, no, and that is something that we tried to do. We worked also with the Motor Vehicle Commission because, as you know, this commission is jointly we're jointly regulated when it comes to public automobile auctions, so
Right.
it has to come from both places. So we work together with the with the Motor Vehicle Commission too. We both submitted similar proposals together.
I mean, this is such a simple thing. All they want to do is hire some auctioneers to call bids. I mean that's all we're. It's not rocket surgery.
Are we up against something that we don't know about, like a faction that doesn't want this to happen, like the automotive industry or anything like that? Because, like he said, this is so common sense. I can't believe there's not a way to fix it.
Right. What we are up against is that we are one of many parts of the department, and our department only has so many proposals that they pick up every year, and we didn't get picked up in that number this year. And so that's what happened here. I don't know about any other factions. I don't know about that. That's something I don't have those pulses or information on the industry. Maybe other individuals do. It seems like an easy fix to me, but I don't have that information in front of me.
We appreciate your efforts very much, but we do need to get this fixed.
I think it's just a clarification issue. When somebody calls like Bob and says, I want to get my licenses.
Yeah, but you got to go by the law.
Yeah.
That's the problem.
Clarification is important. This is what you got to do to get it. Okay.
Well, at our next
how do we
meeting,
do
if
that?
we could have some language that we could disseminate to members.
Sure, I will work with whoever wants to work with me to get whatever language for it. But that is, I think, what would be best.
Okay. We'll work on that.
Very willing to do that.
Thank you.
Members, anything else to address before we end our meeting today?
Yeah, I think
That
beat this
is-
horse to death.
It's not the first time though. So, if there's no other business to conduct, I would need a motion to adjourn. It's to adjourn the meeting. It is 10:30.
Turn.
Good night, and a second by Jeff Morris. I will assume all are in favor of adjourning our meeting for today. Thank you so much. And Dana, you can go ahead and stop our recording. Thank you, everybody that participated, and thank you, Mr. Kimball, as well. Thank you.
This meeting is no longer being recorded. This meeting is no longer being